President. Article 52 to 78 in Part 5 of the Constitution deals with the Union Executive. In Part 5 of the Constitution, Union Executive, we will be having Article is 52 to 78. Just add a 2 over here, it is 7 and 8. So 52 to 78 deals with the Union Executive. Right. Union Executive is under the Union Executive is under the President. Even Prime Minister comes under Union Executive, and we have various persons like Attorney General comes under the Union Executive, right? So from Attorney General Article 76. So Article 52 to 78 is related to the Union Executive. President is the head of the Indian state and he is the first citizen of India. Who is the president? President is the head of Indian state. The first citizen. President is the head of the Indian state and then they are the first citizen of India. The office of the president came into existence immediately after the constitution was adoption of the constitution in the 26th November 1949. So office of the president, right? The office of the president, it came into existence immediately after the constitution was adopted in 26th November. We have the 26th November 1949. 26 November 1949. Right. Union Executive is going to consist of the President, Vice President. So we'll be having the President. And there is also a Vice President, VP. President, Vice President. And then they also consist of the Prime Minister, Council of Ministers. And then they have the Attorney General. Attorney General. President, Vice President, Council of Prime Minister, Council of Ministers, and then we have the Attorney General of the India. The qualification, what is the qualification for election as the President? They must be the citizen of the India plus completed the age of 35 years. Right, citizen plus completion of 35 years. It is the qualification. And qualified for election as a member of the Lok Sabha. They are qualified for election as member of Lok Sabha. Election as member of Lok Sabha. This is the qualification for the president. The age is 35 and qualified for election as a member of Lok Sabha. He should not hold office of profit under the union government or the state government or any public or local authority. No office of profit. So we say that there is no office of profit. Right. And example note in the sense, what is the sitting president or of vice president of union, governor of any state, and a minister of the union, the sitting president, vice president, governor, ministers of union or any state is not deemed to hold the office of the profit. Nobody, that is, the executive must not hold an office of profit. Right. We say that the simple rule is who should not hold the office of profit. The executive should not hold an office of profit. If you say president is a executive, vice president is a executive. Executive vice president is executive, governor is executive, and ministers belong to the executive. Either union executive or the state executive, they should not hold the office of profit. So one thing which we have to note down for the office of profit is office of profits is not for the executives. The executives should not hold office of profit. Oath or affirmation of the president is administered by the Chief Justice of India and in his absence, the senior most judge of the Supreme Court. When he is absent, the next in line is the senior most judge of the Supreme Court, right? So who takes the oath or affirmation by the president is under the administration of Chief Justice of India. Let us go for a recap from now. The executive, union executive, the articles for not for the president. The articles for the union executive is 52 to 78 is the articles for the union executive. These are the articles for the union executive, right? Article 52 to 78 is the articles for the union executive. 52 to 78. So this is the first important points, like articles 52 to 78 in part 5 of the constitution deals with the union executive. That too in the part 5 of the Constitution. So the part 5 of the Constitution, they deal with the Union Executive. Articles is going to be 52 to 78. So 52 to 78 in the part 5 of the Constitution. So we will be having the part 5 of the Constitution. They deals with the executive, Union Executive. The President is the head of the Indian state and the first citizen of India. So we'll be having the President. And the President is going to be like the head of the Indian state. Right? President is the head of the Indian state and he is the first citizen of India. How do we describe a president? Head of the Indian state, India as a state, right? Indian state. And the first citizen. Office of the president came into existence immediately after the constitution was adopted on 26th November 1949. When did the office of the president came into existence? On 26th November 1949 is the office of the president came into existence. The Union Executive is includes of the president. Executive includes the president, vice president, and then we have the prime minister, council of ministers, attorney general. So these are the people, the prime minister and council of ministers, article 74, 75, attorney general, article 76, right? President, vice president, prime minister, council of ministers, and attorney general. These are the people who involved in the Union Executive. So when we are dealing with Union Executive, we need to learn about the President and Vice President, Prime Minister, his Council of Ministers, Attorney General, Article 76. Now what is the qualification for the President? Must be a citizen. The first qualification is a citizen. He or she must be a citizen and 35 plus is the age limit. And they must be qualified to be elected as a Lok Sabha member. Qualified for the election of a Lok Sabha member, right? He should not hold office of profit under the union government or the state government or any other local authority. So who does not hold the office of profit? The office of profit is not held by the executives. The executives do not hold the office of profit. Oath or affirmation by the president, right? The oath of a president is administered by the Chief Justice of the India and in his absence a senior most judge. Now what are the conditions for the president's office? He should not be a member of either house of the parliament or house of the state legislature. These conditions we just need to remember. He should not be a member of both the houses of the parliament or the state legislature. He is not a member of the parliament, or we can say that he or she is not a member of the state legislature as well. They do not hold office of profit. Office of profit is Article 59 is where we say that they do not hold office of profits as any office which bears various pecuniary benefits or may be capable of yielding pecuniary benefits. An office from where we have benefits. So Article 59 deals with the president not holding an office of profit. The expression office of profit has not been defined in the Constitution and in the Representation of People's Act 1951. So office of profit is not defined in the Constitution as well as in the Representation of the People's Act 1951. Right. Now, first thing is he or she should be the member of either house of the parliament. They are the member of either the Lok Sabha. They should not be a member of either the Lok Sabha or the Rajya Sabha, right? They are not the member of the house of parliament or even the state legislatures. They do not even hold the office of profit, right? So office of profit option is also being eliminated. And office of profit is being explained in Article 59 as the Prime Minister should not hold the President should not hold the office of profit. He is not the bearer of office of profit. Office of profit in itself is not defined in the Constitution, either in Constitution nor in we say Representation of the People's Act of 1951. Its scope can simply be inferred from the pronouncement of the courts and other competent authorities such as the Election Commission and the President. So what is the office of profit? It's not present in Constitution as well as Representations of People's Act 1951. The scope is simply inferred to the pronouncement of the court. The court must decide the office of profit and other competent authorities as the election commission and the president. Entitled without the payment or rent, the use of his official residence, also entitled for emoluments, allowances, privileges may be determined by the parliament. So whenever it comes to question like emoluments, allowances and privileges, right? Emoluments, allowances, and then we have the privileges. It is under who? It is under the parliament made by law. The parliament by law. Whether it is an emolument or it is an allowances or it can be even a privilege. These things are parliament by law. So when parliament is subjected to these things, it cannot reduce it to the disadvantage of the president when the president is in the office. During the term of office, the emoluments and the allowances of the president cannot be diminished during his term of office. Right? When they are working, we cannot reduce their allowances or emoluments by a parliamentary law. These are the conditions of the president's office. So once we are recapping the conditions of the president's office, the first thing we can say is that they are not a member of either house of the parliament or even the house of the state legislature. They do not hold any office of profit is mentioned in Article 59 of the Constitution. Office of profit is an office which carries various pecuniary benefits or is capable of yielding pecuniary benefits. The expression office of profit has not been defined in the Constitution or in the Representation of the People Act 1951. Its scope can be simply inferred from the pronouncement of the courts and other competent authorities such as the Election Commission and the President. They are entitled without payment of the rent, the use of his official residence, and also entitled to such emoluments, allowances, privileges as may be determined by the Parliament by law. This cannot be diminished during their term of office. Election to the President of India is by proportional representation, single transferable vote. Right. The President is elected by the Electoral College. The Electoral College is going to consist of only the elected members. The Electoral College will consist of only the elected members, right? Because why nominated members are not included? The nominated members are not included because, for example, let us take Rajya Sabha. There are 12 nominated members. They are nominated by the President himself. So when there are two candidates for president, he is going to convince people like already nominated 12 people. If you put vote for me, you are a nominated member. I will nominate you again in the Rajya Sabha. Right? They will try to lure them. That is why nominated members are not included. So nominated members are not included in the election. Only those elected members, the two we have the Lok Sabha, elected members of Lok Sabha and Rajya Sabha, right? We have the elected members of Lok Sabha and Rajya Sabha. Then the elected members of the legislative assemblies. Here we have to know that there is no legislative councils are not taken into consideration. The legislative councils, they are nothing but the members from legislative assembly. The members from the legislative assembly, they vote for the legislative councils, right? So these legislative councils are not taken into consideration. Elected members of the legislative assemblies of the states, elected member of the legislative assemblies of Union Territories of Delhi and Puducherry, the nominated members of Lok Sabha, Rajya Sabha, state legislative assemblies and the members of the legislative councils whether they are elected and the nominated members of the legislative assemblies of Delhi and Puducherry or do not participate in the election of the president. Right. Now we have learned about the electoral college of the president. The electoral college of the president is going to consist of, right, the elected members of the Lok Sabha and Rajya Sabha, elected members of the Lok Sabha and the elected members of the state legislative assemblies, elected members of Delhi, and then we have the Puducherry state legislative assembly. Delhi Puducherry State Legislative Assembly. Right. Nominated members of any house and even the members of the legislative councils, whether they are elected or nominated, they do not participate in the election of the president. There is a reason for this indirect elections. Direct elections are costly and they are time consuming. For fear that directly elected president may become center of power of his own. Right. Because the direct elections are costlier and that they are time consuming. Factual thing. The direct elections is costly and they are time consuming. They have a fear that a directly elected president, right, they may become a center of power in his own right. Directly elected president can remain real and substantive powers, causing conflicts. Important points is Article 71. We have 4 and Article 71. Right. 71(4) protects the president's election from being challenged on the grounds of existence of any vacancy among the members of the electoral college electing him. All the disputes arising in connection with the election of the president are to be decided by the Supreme Court is Article 71. Right. Article 71(4) is going to elections of the president is being challenged on the grounds of existence of vacancy among the members of the electoral college electing him. If there is a vacancy in the Lok Sabha seat, you cannot cite this vacancy for nullifying or challenging the election as a ground for challenging the election of the president. Right. So Article 71(4) is very important. And all the disputes in connection with the election of the president are to be decided by. If there is a dispute in connection with the election of the president, such a dispute is decided by the Supreme Court. If there is a dispute, they say that the dispute is dealt by the Supreme Court. So Article 71 is very important. Article 71 is related to Supreme Court's original jurisdiction. Supreme Court is having original jurisdiction over the election of the president. Under which article? Article 71. And the election cannot be challenged on the ground of existence of any vacancy. On ground of existence of any vacancy. Right. On the ground of the existence of any vacancy among the members of the electoral college electing him. Under the Presidential and the Vice Presidential Elections Act of 1952, an election can be called into question either by a candidate at such election or by 10 or more electors. Who can call the question of the election? It's by the candidate at such election or by the electors. 10 or more electors by the candidate who's participating into the election, right? This candidate himself, or we need to have the electors, we say 10 or more electors. Candidate or 10 or more electors. Supreme Court has held that the person who is neither a candidate nor an elector could not file the petition to challenge the president's election. Who cannot file a petition? When you are not neither a candidate nor an elector. Elector, that is the elected members of the Lok Sabha, and then we have the Rajya Sabha. And state legislative assembly, elected member, they are the electors. So 10 plus members of the electors, they can go and give a petition to the Supreme Court for challenging the election of the president. Under the President's and the Vice President's Election Act, there is a separate act. It is not given in the Constitution. Okay. So it is having a separate act. Now, from this to this, what are the questions possible? The first question possible is the original jurisdiction of the Supreme Court with respect to president's election is mentioned in the which article? It is mentioned in Article 71. Right. And the next question is on what grounds? President's election cannot be challenged. What is the ground? The vacancy in electoral college. So this is in again Article 71(4). The next question is who can challenge? President's election. We have it as a candidate appearing for it / 10 plus electors. Now that's it. And under what? Under what law? Under what law or constitution? It is under the law or a act, right? President and Vice President Elections Act 1952. President and Vice President's Election Act of 1952, right? Under this act. So it is under the President and then the Vice President's Election Act of 1952. Election processes is going to be the vote of the MLA. Vote of the MLA is the total population of the state, number of MLAs, number of the elected members in 2000. Now total population divided by the number of elected MLA in 2000 over here, right? So total population divided by number of elected into 1/1000. Vote of MP is equal to total population of the MLA divided by the total number of the elected members in Lok Sabha plus Rajya Sabha. The value of the vote of each MLA varies from states to another, but election is by proportional representation by means of a single transferable vote. For MLA alone, we are using the total population of the state divided by the number of elected members into 1000, right? It is not 100. For MP, it's the total value of the MLA divided by the total number of elected members of the MLA, Rajya Sabha and the Lok Sabha MP. Value of the vote of each MLA varies from state to state. Election is by proportional representation, single transferable vote. Proportional representation, single transferable vote. And voting is a secret ballot under Article 55. So Article 55 deals with voting through a secret ballot. All the disputes of the presidential elections is resolved by the Supreme Court. The election of the president is declared void by the Supreme Court. The acts done by him before date of such declaration are not invalidated and they continue to remain in force. In the presidential election, the value of the votes of each member of the parliament is the same. However, the value of the votes in case of legislative assemblies is different from state to state. The value of MPs has been fixed at 708 since 1997 election. In 2015 election poll, vote of MP is reduced to 700 from 708 due to the absence of the legislative assembly in Jammu and Kashmir. Highest number of elected assembly seats lower the value of MLA of the seat. How does single transferable vote works? An elector has to vote single vote with multiple graded preferences. The election can indicate preferences with appropriate numerals against a candidate's name printed in the ballot paper. The vote is initially allotted to the most preferred candidates, yet each one has the potential to carry their over through multiple counts depending on election of the elimination of the candidates. Process of redistribution or transfer of the surplus votes from the elected candidates and of votes and the least successful candidates continues until the required number of members, which is one in the present case of the president and the one in the case of the vice president, is elected and or reach a quota of votes required by a winner. Because votes cast for losing candidates and excess votes cast for winning candidates are transferred to voters' next choice candidates, single transferable system is said to minimize wasted votes. Term of office is 5 years. Even after the expiry, he can continue until the successor enters. So Article 55, what it is? It is related to secret ballot. Article 55, right? Next we have another article. Article 71 related to the Supreme Court role with respect to the president's election, right? So far as now we have seen Article 71 and Article 55 itself. Impeachment Article 61. Supreme Court Article 71. 55 is secret ballot. So 3 articles. 61, 71 and 55. Term of office of the president. Right. What is the term of the office of the president? Article 61. Article 61 is related to the impeachment, right? Impeachment and Article 61. Only on the grounds of violation of the Constitution. So the president is impeached on only one ground. That is the violation of the Constitution. On the grounds of violation of the Constitution does not define the face violation of the Constitution. It is a quasi-judicial process. It is half judicial process. All the elected and the nominated members of the parliament takes place in the impeachment of the impeachment procedure is where we have the elected and the nominated members of the parliament takes place in the impeachment procedure. Right. Impeachment is under Article 61. Article 61 deals with the impeachment only on the grounds of the violation of the Constitution. So impeachment is done on only one ground, that is the violation of the Constitution. Right. The Constitution does not contain the phrase we have the violation of the Constitution, right? It does not contain the phrase violation of the Constitution. It's a quasi-judicial process. So half judicial, right? Quasi-judicial processes. Elected and the nominated members of the parliament takes place in the only the members of the parliament. Members of the state legislature do not participate in the impeachment of the president. It can be initiated in either house of the parliament. It is signed by 1/4 of the members of the house and 14 days notice to the president. 1/4 members and 14 days, that is the 2 weeks notice to the president. 1/4 members of the house is to sign it and then they give a notice and the resolution is passed by a special majority is 2/3 majority by both the houses. The president has the right to appear and to be presented at such investigation. Appear in such investigation and then we say that presented in such an investigation. Investigation at either house itself or some agency which is nominated by the house, maybe nominated members of the Lok Sabha, Rajya Sabha can participate in the impeachment process. Elected members of the state legislative assemblies and the union territories do not participate. No president has been impeached so far. Now, what is the impeachment procedure of the president? Impeachment is done only on the grounds of violation of the Constitution. When the Constitution is being violated, right? The Constitution, it does not define the phrase violation of the Constitution. It is a quasi half judicial body. All the elected, we say that the elected and the nominated members of the parliament. They are elected as well as they are nominated. They take part in the impeachment process. Members of the state legislative assembly do not participate in the impeachment process of the president. And it is signed, initiated in either house and 1/4 of the members is going to sign 14 days. Special majority. President to appear and to be represented at such investigation. Investigation may by the House itself or by some agencies the House may direct. Nominated members of the Lok Sabha and the Rajya Sabha can participate in the impeachment process. Elected members of the state legislative assemblies do not participate in the impeachment. No president has been impeached so far. Comparison of the impeachment process of the Indian and in the US president. President can be removed from the office for the violation of the constitution. Impeachment can be initiated by either houses of the parliament. Any member of the representatives can initiate a resolution for the impeachment if the suspect president is guilty of treason, bribery, or other high crimes or misdemeanors. It is having many like treason, bribery, or other high crimes or misdemeanors. These charges should be signed by 1/4 of the members of the House, the frame charges, and 14 days notice period. The House of Representatives consider the charges if a simple majority, 51% support the impeachment, the process moves to the trial. So the representatives, we have two houses, right? The House of Representatives is where they consider the charges. And here, if the simple majority for the moves for the trial begins, Chief Justice of the Supreme Court presides over it, while members of the House form the prosecution and senators act as jury. President can appoint the defense lawyers. Under the trial, we have the Chief Justice of the Supreme Court. They are presiding, while the members of the House form prosecution. And then act as a jury is the Senate, House of Representatives and House of the Senate, right? The Senate, the House is going to act like a prosecution, and the Senate, he can appoint lawyers. At least 2/3 of the Senate find the president is guilty. He is removed from the office and the vice president takes over for the remaining of the term. After the impeachment resolution is passed by a majority of 2/3 of the total membership of the House, it is sent to the other House, which is acting as an investigates the charges. The other House is here. Next, it is going to investigate the charges. The other House passes a resolution by a majority of 2/3 of the total membership. Then the President stands impeached from the office from the date on which the resolution is passed. What is the comparison of the Indian and the US President? Indian President is the only head of the state or a titular head, whereas the US President is both the head of the state as well as the head of the executive. Holds a period of 5 years, but he holds a period of 4 years and re-elected any number of times but re-elected only once. Indian President and both the houses together make up the parliament. The US President is not a part of the legislature. Indian President has lesser powers of veto comparatively than the US President. US President may veto the bill that was passed by the Congress. So Indian President has less veto powers, whereas the US President is having more veto powers, right? Indian President, and then we have the British Crown. Indian President is elected through the voting. The royal family takes the decision to choose them, and one generation after the generation gets a right. Everything is hereditary in case of the British. Head of only one country. He is the head of the Commonwealth of Nations, that is the head of the British Crown. Indian President has a fixed term of his own after completing which he has to leave the office. This does not happen with the king or the queen sitting on the royal throne in the Britain. There is no such rule for the president in India. Constitutionally, the president cannot be questioned. Member of the British Parliament, that is the Lords, House of the Lords, alone can ask question to the ruling sitting on the royal throne. which they have to answer. In case of a vacancy, due to death, resignation, or impeachment, when the election is declared void by the Supreme Court, he becomes disqualified to hold the office anymore. If the office falls vacant by resignation, removal, death, or otherwise, the election must be held within 6 months. Vice President acts as new president until the election. New president will enjoy a full term of 5 years. The vacancy is caused by the expiration of the term of the sitting president. The election must be completed before the expiry of the term. No scope for the vice president to get a chance to act as a president. The vice president is vacant. Chief Justice of the India or the senior most judge is going to act as a president. Enjoys the powers and immunities as well as salaries, allowances which are available to the president. President, otherwise vice president will occupy it. Otherwise, we have the Chief Justice of India occupying the post. What are certain presidential privileges? He is not answerable to any court for the exercise and performance of his powers and duties of his office. Not answerable to any court, right? The president is not answerable to any court for the exercise of his duties and performance of the office powers. He is not amenable to any mandate, writ, or direction from any court. He enjoys immunity under Article 361 from legal liability of his official acts of commission and omission. Article 361 is a personal immunity from liability. Now, what are the articles which we have seen so far? 61, 71, 55 and 361. (61, 71, 55, 361). He enjoys a personal immunity, right, under Article 361. So, under Article 361, there is a personal immunity as well. And from the legal liability of his office, official act of omission, because of his official acts. Immunity for his official acts of omission and commission. He is immune from any criminal proceedings during his term and cannot be arrested or imprisoned. Civil proceedings can be instituted against him during the term of office in respect to his personal act after giving a 2 months notice. So we say that there is a 2 months notice is needed for the civil proceedings. House of Parliament can question any act of the President only during the impeachment process. What are the powers and functions of the President? He has various powers like the executive powers, legislative powers are the integral part of the Parliament because he is an integral part of the Parliament. Right. Legislative powers are very big. Judicial powers. Diplomatic. Military. Veto. Veto is a power. Then miscellaneous power. Rule making power. Ordinance is legislative power. Rule making power is rules and orders and instruments authenticated. It does not come, ordinance does not come in the rule making power. And the veto ordinance making power, ordinance is Article 1 to 3. Pardoning is also a power, right? The different pardoning powers of the President. Let us see the small topics first. What is the executive power? Executive power of the Union of the India is vested in the President, right? So who is the executive head? The President is the executive head. And all the executive actions of the Government of India are formally taken in his name. Makes rules for the transaction of the business of the Union government. Appoints a Prime Minister Council of Ministers, Attorney General, CAG governance. Declare any area as scheduled area. Appoint an interstate council. So what are the things here which we face difficulty with respect to his executive power? Now here the executive power, in the sense the power of the Union of India is vested in the President. Right. He makes all the executive actions of the Government of India are formally taken under his name. Makes rules for the transaction of the business of Union Government. So he is making rules for the transaction of the business. Right. Then appointment. PM. So appointment is a fact. Appoints PM, Council of Ministers, Attorney General, CAG governors. Declares any area as scheduled areas. First the executive actions, second we will be having the appointments. First is the executive actions, all the actions, right? Executive actions and transaction of the business of the Union Government. Third is the appointments and declaring any area as a scheduled area. Appoint the interstate council as well. Appointment of the interstate council is in Article 263. So what is the article for appointment of the interstate council and who appoints the interstate council? The president appoints the interstate council. Right. So interstate council and scheduled area under Schedule 5 of the Constitution. Declare any area as a scheduled area is Schedule 5 of the Constitution. Appoint the interstate council. Who appoints the interstate councils? It is appointed by the president. And who is the chairman? Home Minister is the chairman for the interstate councils. Now, executive powers is the executive powers. We have seen that all the executive actions of the government of India are formally taken in his name. Makes rules for the transaction of the businesses. Right. Appoints Prime Minister, Council of Ministers, Attorney, CAG. Declares an area as scheduled area, appointment and interstate council. What are the legislative powers? We will see it later. Now, judicial powers is, even whenever he is appointing an executive, it becomes an executive power. Whenever he is appointing a judiciary member, it becomes a judicial power. So he appoints whomever he appoints. He appoints the Chief Justice of India, judges of Supreme Court and High Court. Right. So he appoints the Chief Justice of India and the judges of Supreme Court and High Court. Whenever he is appointing an executive, it is under his executive power. And whenever he is appointing a legislative, it is under the legislative power. Whenever he is appointing a judicial member, it belongs to under the judicial power, Chief Justice of India. Right. And then the judges of the Supreme Court and then the High Court. Seek advice of the Supreme Court is Article 143. Advice tendered by the Supreme Court is not binding, but this advice is not binding on the President. He is going to seek the advice, but this advice is not binding. He can grant pardon, reprieve, respite, remission, suspend, remit, compute the punishment of any offence in Article 72. Pardoning power of the President. Pardoning power of the President is under the judicial powers, right? So the pardoning powers of the President, and even when he is asking the advice of the Supreme Court, all of these becomes the powers of the President, judicial powers. So when he is appointing a judicial authority, it becomes a judicial power. And when he asks for advice of the Supreme Court, seeking the advice of the Supreme Court under Article 143. Seeking the advice of the Supreme Court under Article 143. However, the advice tendered by the Supreme Court is not binding. Right. So here we'll be having that pardoning powers also comes under the judicial powers. So pardoning powers falls under the judicial power. Right. Grant pardon, remission, reprieve, suspend, remit, compute the punishment. When punishment or the sentence is by the court martial. So when they are providing a punishment by the court martial, when there is an punishment for the offense against the union law, even court martials are included under the president's pardoning powers. This is a pardoning power under the judicial powers. Now, all the cases where the person is given a death sentence and when the punishment is against union law, court martial, and when he is given a death sentence, pardoning power is in the exercise of aid and advice of the Council of Ministers. Right. No specific guidelines to the president in the exercise of his pardoning powers. Pardoning powers and then the appointing advice. First he appoints them, then he seeks advice of them, and granting of the pardoning powers. In case of it is a court martial. The pardoning power is in the case of court martial or when the punishment is for the union law. Right. In the case if it is a death sentence. Right. When we are having a death sentence. And then the pardoning power is to exercise on the grounds of aid and advice of the Council of Ministers. There is no specific guidelines to the President on the exercise of the pardoning powers. Now, what is the diplomatic power? The international treaties, agreements approved by the parliaments are negotiated and concluded in the name of the President. When there is an international treaty, this treaty is concluded in the name of the President. The international treaty is negotiated, concluded in the name of the President, right? Then we have represent India in international forums and affairs. They are going to represent India in all the international forums, and then we have the affairs. He sends, and then we have to receive the ambassadors and other diplomatic representatives. Send ambassador, receive ambassador, and then we have other even the diplomatic representatives. So while sending the ambassadors and represent India in different forums, sends and receives the ambassadors, represent India in the international forums, and international treaties and the agreements approved by the parliament are negotiated and concluded. Right. What is the military power? Is the supreme commander. Supreme commander of the armed forces. So we say that they are the supreme commander of the armed forces. The supreme commander of the armed forces, the power to declare war and peace, but his military power is subject to the regulation of the law. He is the one who is going to declare the war, and then they are going to declare war or even the peace. Right. So the declaration of the war or the peace is by the president. Now he appoints the chief of the army, the chief of the navy, and then the chief of the air forces. When the president is appointing the chief of the army, navy, or Air Force, it becomes under the military power. So what is the military powers? The Supreme Commander of the Armed Forces. Therefore, he is going to appoint Supreme Commander of the Armed Forces, appoint them and declare war and peace, but this is in regulation of law. So the Supreme Commander who appoints everybody and declares war and the peace. What is the diplomatic power? International treaties or agreements are approved by the Parliament, but they are negotiated and concluded in the name of the President. We have many international treaties, right? So the international treaties and the agreements, they are approved by the Parliament. Who is approving these? Parliament is the one which is approving this. But the negotiation and miscellaneous powers. A tribal council may be established by the direction of the President in any state having scheduled areas and also in the states having the scheduled tribes. Right. So when there is a schedule 5 is under the schedule 5, and there are people belonging to the scheduled tribes and in the scheduled areas. ST and SA, scheduled tribes and scheduled areas. These people, they require, right? They require a tribal council. So this tribal council is established by the direction of the President. Establishment of a tribal council, right, under the direction of the President. A tribal council is being established over here. He has the power to give instructions to the governor to promulgate an ordinance. If a bill containing the same provisions requires a previous sanction of the President under Constitution Article 231. They say that he has the power to give instructions to the governor to promulgate ordinance. Right. Governor, we know that the governor can promulgate ordinance under 213, Article 213. But the President is having the power to give instructions to the governor to promulgate ordinance if a bill containing same provisions requires the previous sanction of the President under the Constitution. President can declare an area as scheduled area, enter the boundaries of the scheduled areas. Declaration of an area as scheduled areas, and then there is a need for the tribal councils in that area. President can instruct the governor to promulgate ordinance. These are related to ordinance and then the mercy petitions, right? Pardoning power. Now, all the small topics related to the special powers of the President are completed. Right. We have seen the miscellaneous powers. What does they say in the miscellaneous powers? First, we be having the President is declaring an area to be a scheduled area. Who declares the area to be a scheduled area? The President declares an area to be a scheduled area and enter the boundaries of the scheduled areas. So we have the President who is declaring an area as a scheduled area. Right. Now, has the tribal council setting up establishment by the direction of the President. Establishment of a tribal council, tribes council. Declare an area as scheduled area and establish a tribes council. Then has the power to give instructions to the governor to promulgate ordinance if a bill containing the same provision requires the previous sanction of the President under the Constitution. Instruct the governor to promulgate the ordinance under Article 213. We didn't see veto power. We have seen the military powers. Now let us see the veto power. A bill is passed by the Parliament. It can become an act only if it receives the assent of the President. Assent. Here we have to know few terms. Gave the assent means he has signed the bill. Withhold means he has rejected the bill. Withhold means he is just rejecting. Okay. When here there is a bill, here is the place where he has to sign. When he signs, he gave assent. When he is cancelling, just when the place of his signature, he is just cancelling. It is withhold. He just rejected the entire bill. He just rejected the entire bill is what we call it as a withhold. Right. He is returning. When the bill is presented, he is doubtful, so he is returning the bill. If not money bill for reconsideration of the parliament. Money bill assent or withhold. Money bill cannot be returned. So we must note that the money bill cannot be returned. Right. There is no returning for the money bill. Money bills cannot be returned. So what we have to tell? The money bills cannot be returned. There is a money bill and the money bill cannot be returned. That is what we can say. So we are having the money bills and the money bills cannot be returned. What are the alternatives under Article 111? 111 is related to the veto power of the president is mentioned in Article 3.1, assent of the president. Right. When a bill, what are the situations when a bill is presented in front of the president? A bill. It is passed by the parliament. It can become an act only if it receives the assent of the president. Right. Only when the president signs it. There are three alternatives for the bill. The first one is going to be the president giving the assent to the bill. And the president is withholding and the president is returning it. If not, the money bill is not having risen, must either assent or he must withhold. For the reconsideration of the parliament. If a bill is passed again by the parliament with or without amendments and are presented to the president must give assent to his bill. Right. First, the president has rejected the bill, but the bill is passed again. He must sign it. He must give assent to the bill. So the president enjoys three different veto powers. There is no qualified veto, but is overdriven by the legislature with a higher majority. There is no qualified veto. What is qualified veto? First, when the president rejects a bill, initially the bill got 100 votes. Next, the bill must get more than 100 votes. This is what we call it as overridden by legislature with a higher majority. Overridden with a higher majority. There is no qualified veto. Overdriven by with a higher majority. Absolute veto, it is to withhold the assent, then the bill is going to end. It is available for the private member bills. Usually private member bills, and then we have when the cabinet resigns. They tell to, withhold the bill. Withhold the bill is going to end. Again, it must be passed newly, right? So withhold the assent in the sense the bill is going to end. Therefore, it is available for private members bill and when cabinet is going to resign. Cabinet is going to resign. And then we have the private members bill. Private members bill. And when the cabinet resigns. Now, what is a suspensive veto? When the bill returns for reconsideration, no suspensive veto available for the money bill. Suspensive veto can be overridden. Returning of the bill is what we call it as a suspensive veto. And pocket veto is when he is not acting over the bill is what we have the pocket veto. Returning of the bill, it cannot be done for a money bill. The bill cannot be written in case of a money bill. Suspensive veto can be overridden by the repassage of the bill in the parliament. When the parliament resends the bill to the president, it has to follow only the ordinary majority in the houses and not a higher majority. Again, they have to go for voting. Pocket veto is simply keeping the bill pending for an indefinite period, no action. But in USA, the president has to return the bill for reconsideration within 10 days. In 1986, President Jayal Singh exercised this pocket veto. No pocket veto is available for the Constitutional Amendment Act. It has made obligatory for the president to give the assent to the Constitutional Amendment Act. Now we have completed the veto as well. We are going for multiple revisions. What is a veto? Power of the president. Bill is passed by the parliament, right? It can become an act only if it receives the assent of the president. But a bill can become an act only if the president signs the bill, right? Now, there are three options or alternatives which are available, and this is described under Article 111. So far, what are the articles we have seen? Article 61, 71, 55, 111, 1, 2, 3. We will have a separate discussion on articles alone. Now, we will try to understand the concepts. Assent, withhold or return. Return is suspensive. Assent is just giving assent, and withhold is absolute veto. Suspensive veto. Returning is suspensive veto and assent is absolute veto. We say assent as withholding the assent as absolute veto. But returning is what we call it as a suspensive veto. For the reconsideration, he can return it. If the bill is passed again by the parliament with or without amendments and presented to the president, he must give his assent. The president enjoys three different kinds of the veto. No qualified veto because they are overridden by the legislature with higher majority. There is no qualified veto. When he can withhold, he can cancel the bill. It is available for a private member's bill, and when the cabinet is resigning, he can withhold the bill. He can reject that bill. What is a suspensive veto? He sends it for reconsideration of the bill. When he sends it for the reconsideration of the bill, no suspensive veto available for the money bill. The first point is money bill is not having a suspensive veto. Suspensive veto can be overridden by the passage of the bill by the parliament. For suspensive veto, we need to pass a bill by the parliament. When the parliament resends the bill to the president, it has follow only ordinary majority in the house and not the higher majority. What is pocket veto? Pending the bill for an infinite period, President Jayal Singh in 1986 has done this pocket veto. Pocket veto is not available for the Constitutional Amendment Bill. This is in the 24th Constitutional Amendment Act of 1971. States that the pocket veto. So the 24th Constitutional Amendment Act of 1971 states that the pocket veto is not available to the president to give his assent to the Constitutional Amendment Bill. We see the military powers. He is the supreme commander of the military. Therefore, he is going to appoint the army, navy, and then air force, the chiefs alone, and the power to declare war and the peace. Diplomatic powers, the international treaties and the agreements, they are approved by the parliament, but they are concluded in his name. Represent India in the international forums. He sends and receives ambassadors and other diplomatic agents. We have seen the judicial powers as well. First is the appointment. Appointment of the Chief Justice of the India, the judges of the Supreme Court and the High Court. So he is involved in the appointment and seeks advice from the Supreme Court. However, the advice tendered by the Supreme Court is not binding on the president. Right. Even though he seeks the advice tendered is not binding on him. He can grant pardon, reprieve, respite, remission, suspend, pardoning powers under Article 72. Pardoning powers. In case of a union law, court martial, and in case where a person is sentenced to death. The pardoning power is to exercise on the aid on the advice of the Council of Ministers. No specific guidelines to the President on the exercise of his pardoning powers. Now, executive powers, right? Executive power of the Union is vested in the President, and all the executive actions of the Government of India are taken in his name. Makes rules for the transaction of the business of Union Government. He is making the rules for the transaction of the business, right? He appoints a Prime Minister, Council of Ministers, Attorney General, CAG, Governors, etc. Declare any area as a scheduled area. And to appoint the Interstate Council, right? So, appointing the Interstate Council, declaring an area as a scheduled area, appointing, making rules. Now, what are the legislative powers? Summons the House at least twice a year and prorogues either House of the Parliament and dissolves the Lok Sabha. Summoning and proroguing. Summon, prorogue, dissolve. Summoning, proroguing, and then we have the dissolve, right? Summoning the houses at least twice a year. At least 2 times he needs to summon the house. And prorogue in the sense he needs to end that session. Summoning is beginning of the session and prorogue. So we have the summoning and the proroguing of the houses. But dissolving is with related to the Lok Sabha alone. The summoning and the proroguing is for both the houses. He needs to summon at least twice, right? But the prorogue is for only one house. Joint sitting. He calls for a joint sitting, summons both the houses for joint sitting for debating, voting on a bill in case of a deadlock. He is going for a joint sitting, right? Summon both the houses for joint sitting for debating, voting on a bill in case of a deadlock. At the commencement of the first session after every general election, the President delivers an address. Address is delivered by the President. So this is his legislative powers because he is an integral part of the Parliament. First, let us initially relook into the 3 which we have discussed. The first activity he does is summon. The second activity is just prorogue. And the third activity is dissolve. Summon, prorogue, and then we have the dissolve. So, summon is nothing but starting at least twice. Prorogue both the houses, but dissolve is only in the case of the Lok Sabha. And he is going to summon the joint sitting for debating and voting. He goes for the joint sitting. Right. For debating or voting on a bill in case of a deadlock. He is going for a joint sitting. At the commencement of the first session, after every general elections, the President delivers an address. President delivers address. Commencement of the first session after every general elections, President is to deliver an address. Appoint speaker, appointment, everybody who is related to the legislature, if he is appointing them, it belongs into the legislative powers. Right. He appoints a speaker and deputy speakers when the office is vacant. When the office is vacant, he just appoints them temporarily. Then election for the speaker and deputy speaker takes place. Right. So he appoints a speaker and a deputy speaker when the office is becoming vacant. We say that when the office is becoming vacant, he appoints the speaker and deputy speaker. Nominates 12 personalities to the Rajya Sabha. Decides a disqualification of the members in with election commission. We are revising 3 points at a stretch. So the first point is whenever the office of the speaker or the deputy speaker becomes vacant, they are appointed temporarily by the president. He appoints a speaker and a deputy speaker when the office becomes vacant and nominates 12 personalities to the Rajya Sabha. It decides the qualification of the members with the disqualification with the election commission. Summoning related to the House and joint session. Summon, prorogue and dissolve. Joint session, and at the commencement of the first session, the president is delivering an address. Speaker and a deputy speaker. Nominates 12 personalities to the Rajya Sabha. Decides disqualifications of the members with the election commission. And he issues the ordinance making powers. Ordinances, right? Every bill passed by the parliament, it becomes a act only after receiving the assent of the president. Can give his assent, withhold his assent, or return the bill to the parliament with his own suggestion, a bill other than the money bill or the constitutional amendment bill. So the next 2 points is over, 3 points is over. Right. He can issue an ordinance. Ordinance making power, and he must give his assent or withhold his assent or even return his assent to the parliament, except a money bill and a constitutional amendment bill. Now, every bill is passed by the parliament must receive the president's assent before it becomes a act. Right. So these are the powers, legislative powers. The president may accept the parliament may accept or reject it, but if it is sending again the president's assent, now the president has to give his assent. Right. When the parliament is sending again, with or without corrections, he must act on it. When the bill passed by the state legislature is reserved by the governor for the consideration of the president, can give his assent or withhold his assent, direct the governor to return the bill for reconsideration. It is not obligatory for the president to give his assent even if the bill is passed again by the state legislature. Right. Now, let us discuss these 3 alone. What does it say that? If the parliament, we say that the parliament accepting his suggestions or not. Right. The parliament is accepting his suggestions or it is not accepting it, rejecting it, but it is sending again. Then the president must act on the bill. Then they say that the president must compulsorily act on the bill. When the bill is passed by the state legislature, now the state legislature comes into picture and the bill is reserved by the governor. Passed by the state legislature and it is reserved by the governor. For reconsideration, for the consideration of the president is giving assent or withholding the assent, or he is asking the governor to return the bill for reconsideration of the state legislature. It is not obligatory for the president to give the assent even if the bill is passed by the state legislature. He is making regulations for the union territories. Okay. He is making regulations for the union territories. So we have to understand that this is a legislative powers. Because the union territories without the legislature, they need regulations. We say that the union territory without the legislature. So when there is a union territory without the legislature, right, they make regulations from the Andaman and then the Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. Right. So what are the union territories without the regulations is Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. Puducherry is the president can legislate only when the assembly is suspended or dissolved. So the regulations are made for the union territories which are not having any of the state legislative assembly. Puducherry is the president can legislate only when the assembly is suspended or dissolved. Make certain reports and statements to be laid before the parliament. The reports and the statements to be laid before the parliament. Annual financial statement and then the supplementary statement. So these are the reports. What are this we have to revise it separately. And here we have the bills which require the prior permission of the president before introduction. Right, we have two topics. Now let us just go through this first. And then we have more leftovers. This 2 and 3 is leftover. It's just a kind of a revision. Now Puducherry, the president can legislate, right? When the assembly is suspended or dissolved, make regulations. He is making regulations. For the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu. Puducherry only when the assembly is suspended or dissolved. Now, when the bill is being sent to him by the state legislature, the bill is reserved by the governor for consideration of the president. Right. President is giving the assent, withholding the assent, and direct the governor to return the bill for reconsideration of the state legislature. Not obligatory for the president to give the assent even if the bill is passed again by the state legislature. Parliament may accept his suggestion or reject it, but if it is sent again for the president's assent, now the president has to give the assent. What is going to happen if a bill is passed by the parliament? He has to act on the bill. He can either give assent, withhold, or return. If he is returning, it is not subject to the money bill or the constitutional amendment bill. Parliament may accept or reject it, but if it is sending again, the president must sign it. An ordinance making power of the president. Decision on disqualification of the members with election commission. He nominates 12 personalities to the Rajya Sabha. Appoints a speaker and a deputy speaker when the office is vacant. Commencement of the first session. After every general elections, the president delivers an address. Summons both the houses for joint sitting for debating or voting on a bill in case of a deadlock. Summons the house at least twice a year or prorogues either house and dissolves the house. Now we are going to see what all the reports. Right, reports is a session and what are the bills which require prior permission of the president before the introduction. Bills that seek to alter the boundaries of the states and the names of the states. A bill seeking to alter the boundaries of the state and the name of the state, right? When there is an alteration to the boundaries of the state and then the name, money bill and then the financial bill. Alterations to the name of the state's name and the boundaries, money bill, financial bill involving the taxation and distribution of the financial resources to the states. Money, finance, taxation or distribution of the financial resources to the state, and a bill that seeks a restriction freedom of trade. Right. When a bill is restricting the freedom of trade. So these are the things, bills which require is a finance bill, money bill, and then tax and financial resources to the state, right? Altering the boundaries of the state. Bill that seeks restriction freedom of trade. Now, make certain reports and statements to be laid before the parliament. We have the annual financial statement and the supplementary statement, right? The annual financial statement, and then we have a supplementary statement. Annual financial statement is budget. So budget is to be laid by the president. So on behalf of the president, the finance minister lays down the annual financial statement. Annual financial statement is the responsibility of the president, right? And supplementary statement as well. And the report of the CAG, report of the UPSC explaining reasons where any advice of the commission has not been accepted. CAG, UPSC, National Commission for SC/ST, and Special Officer for the Linguistic Minorities, and the report by the backward classes. Now we'll be having the annual financial statement, right? The annual financial statement is the responsibility of the president. And then we'll be having the supplementary statement as well. The report of the CAG, right? The recommendations of made by the Finance Commission. Recommendations of the Finance Commission, CAG, UPSP, National Commission for SC/ST, and the Special Officer for Linguistic Minorities. Report of the Commission on the backward classes. We have completed the legislative powers. Now, what is the financial powers? Because his prior recommendation needed for money bill introduction. Financial powers in the sense the prior recommendation is needed for the money bills, right? So the money bill, when it has to be introduced, it requires the prior permission of the president. Lay before the parliament the annual financial statement. So the annual financial statement is on the behalf of the president. No demand for the grant except on his recommendation. So there is no demand for the grant. Control over the contingency fund of India and constitute the finance commission every 5 years. He needs to constitute finance commission every 5 years. And prior recommendation, we say that the prior recommendation is needed for the money bill introduction. Right. If money bill needs to be introduced, his prior recommendation is necessary. Lay before the parliament, he need to lay the annual financial statement. No demand for the grant except on his recommendation. Control over the contingency fund, finance commission constitution. We have seen the veto power as well. The next is the rule making powers. The rule-making powers. The president can specify how his orders, instruments shall be authenticated. Right. The president is having the orders and then the instruments. And how are these orders and instruments are authenticated? The paying into the custody of and withdrawal of the money from the public accounts of the India. So when it is involved into the public accounts of India, withdrawal of the money. So we'll be having the withdrawal of the money from the public accounts of the India. The number of the members of the Union Public Service Commission. We have the UPSC. The number of the members of UPSC, their tenure, and then we have the conditions of the service of UPSC. Right. Now the conditions of the service, it is related to the UPSC. The president can specify how first is the orders, instruments shall be authenticated. The paying into the custody of and the withdrawal of the money from the withdrawal of the money. We need to focus on the withdrawal of the money from the public accounts and the number of the members of UPSC. We have UPSC, tenure and the conditions of the service. Recruitment and the conditions of the service of the persons serving the union. We are dealing with the recruitment. And then we also deal with the conditions of the service. Recruitment, and then we have the conditions of the service for the persons who are serving the union. If a person is serving the union and the secretarial staff of the parliament, if they are serving the parliament as well. The prohibition of the simultaneous membership of the parliament and the legislature of the state. President has to prohibit the simultaneous membership of the parliament and the legislature of the state. So who prohibits it? The president. It is the role of the president. So recruitment, the conditions of the service, right, of the secretarial staffs of the parliament. Now the last 5 points, if we revise upon, related to the orders and the instruments shall be authentication. So the president deals with the authentication of the orders and the instruments. The paying into the custody of and the withdrawal of the money from the public accounts. He needs to take the custody, right? The custody and then the withdrawal of the money from the public accounts. Custody, and then they say that the withdrawal of the money from the public accounts. The number of the members of the UPSC. Members of the UPSC, the tenure and then the conditions of the service for the UPSC. Recruitment and the conditions of the service of the persons who are serving the union and then the state staff of the parliament. The prohibition of simultaneous membership is in the role of the president. The procedure relating to the joint sitting of the houses, joint sitting and consultation with the chairman and the speaker of both the houses. In case of a joint sitting, the president needs to consult with the chairman and the speaker of two houses. The manner of enforcing the orders of the Supreme Court. So the orders of the Supreme Court must be enforced and it is the duty of the president. Allocation among the states of emoluments payable to the governor appointed for 2 or more states. If there is a governor appointed for 2 or more states, he must look into the allocation among the states of emoluments payable to the governor. Discharge the functions of the governor in contingency not provided for constitution. Specifying the scheduled caste and scheduled tribes. specifying the matters in which it shall not be necessary for the government of India to consult the UPSC. Certain matters it is not necessary for the president to consult for the government to consult the UPSC, right? Related to the scheduled caste and tribes, it is president, and specifying the matters on which it shall be necessary for the government to consult the UPSC. We have the president's veto power over the state legislature. What is the president's veto power over the state legislature? We have the Article 200 and 201. President is having the veto power over the state legislature. Governor to reserve a bill passed by the state legislature. So what is the article which is involved in when governor is resolving a bill for the state legislature? It is Article 200 and Article 201. Right. What does the president do? The president can give assent to the bill. The president can withhold assent. Right. Withhold the assent means the president is rejecting it. Then if it is not a money bill, he can return it for the reconsideration of the state legislature. If it is not a money bill, the president is returning it. After the state legislature has returned the bill to him, he either gives assent or withhold it. Unlike the union legislature, the president is not bound to give his assent to the bill, which has been rescinded by the state legislature after reconsideration. Thus, in case of the state bill, if we are having the state bill, right, the president has veto power, pocket veto, absolute veto, pocket veto, and even the suspensive veto. Now, what is the ordinance making power of the president under Article 123? The ordinance making power of the president is specified under Article 123. Ordinances were included in the Constitution of India from the Government of India Act of 1935. So, ordinance comes into play from the Government of India Act of 1935. Authority of the Governor General to promulgate ordinances. The ordinance making power is derived from the Ordinance Government of India Act of 1935, which gave the Governor General to promulgate the ordinances. President also can promulgate the ordinances only during the recess of the Parliament. Promulgate is only when both the Lok Sabha and as well as the Rajya Sabha is not in session, or either house is not in session. Only when he is satisfied that circumstances exist that render it necessary for him to take action. That too an immediate action. The circumstances render it for him to take an immediate action. Ordinance may relate to any subject that the Parliament has the power to make law. Would have the same limitations. The President may withdraw any ordinance at any time. However, he exercises his power in the consent of the Council of Ministers headed by the Prime Minister. Copper case. President satisfaction can be questioned on the ground of malafide. So the Copper case is 1970. It is related to the president promulgating the ordinance and it is subject to the judicial review. When the Parliament reassembles, both the houses must approve the ordinance before to become an act. Expiry is 6 weeks. So the maximum life is going to be 6 months and 6 weeks. 6 months is the maximum gap between the sessions of the Parliament, right? So 6 weeks, within 1.5 months after the houses are in session, it must be approved. So the maximum life is 6 months, 6 weeks. We have the Copper case, right? 1970 Copper case. The President's satisfaction can be questioned on the ground of malafide. 44th Constitutional Amendment Act, yes, the satisfaction is under the jurisdiction of judicial review. When Parliament reassembles, both the House must approve the ordinance to become an act. Expiry is 6 weeks. The maximum life is 6 months, 6 weeks. Can issue ordinance only on the advice of Council of Ministers. Right. It cannot be used to amend the constitution. Ordinance making power of the president is co-extensive with the parliament but not parallel. Is it parallel? No, it is not parallel. It is co-extensive and it is not parallel. Can be retrospective, may modify, repeal an act of the parliament or another ordinance. It can amend the tax law also. Tax law, it can be retrospective. So this is the most important point. It can amend the tax law as well. Now, rules of the Lok Sabha. Whenever a bill seeks to replace an ordinance is introduced in the House, a statement explaining the circumstances that is necessitated should be placed before the legislature. Now, according to the rules of the Lok Sabha, whenever there is a bill to replace the ordinance, right? A bill is passed and the aim of the bill is to replace the ordinance. Now, here a statement must be explaining the circumstances. What is the circumstance under which it necessitated that an ordinance must be placed? It should be mentioned the president's ability to issue ordinances is justiciable. 38th Constitutional Amendment Act added a new clause, Article 123, states that the president's satisfaction with the issue of the ordinance is final and it cannot be appealed to the court for any reason. But the 44th Amendment made that the president's satisfaction subject to the judicial review, stating that the president's power could be challenged in the ground of law if it is based on bad faith, corruptive motives, and malafide in intents. Copper case also, the president's satisfaction can be questioned in the court. S.R. Bommai case is related to the judicial review. The scope of judicial review was extended and any action the president takes without the relevant materials would be considered to be a bad faith. If the president is doing anything without the relevant material, so if the president does anything without the relevant material, it can be considered as a bad faith. It is done on a bad faith. Now the pardoning power of the president is explained over here. Mercy petition. Differences between the pardoning power of the president and the governor. Right. Article 72 is nothing but the pardoning power of the president. So we have Article 72 and it is related to the pardoning power of the president. It is an executive power, independent of the judiciary. Right. Now, this is an executive power. Pardoning power is actually an executive is having a power and this power is independent of judiciary. So, it means that the president, while he is exercising this power, he does not sit as a court of appeal. He is not like, it is not like an appeal. The pardoning power is not an appeal. It is an executive power and it is clearly independent of the judiciary. Now, what is pardon? Completely absolves conviction. If a person has committed a crime, if he is proven guilty, but due to the pardoning power, he has been absolved from the conviction completely. Let's say 10 years imprisonment. The 10 years, entire 10 years is being cancelled and he is released free. So absolute, completely absolves the conviction is what? Pardon. We just need to remember what is a pardon. Now we are dealing with the pardon alone, right? So what is a pardon? Completely it is going to absolve the conviction. There is some conviction and that conviction is completely absolved. Commutation is substitute to a lighter punishment. Commutation, mutation, you have to, mutation is nothing but a change is what we call it as a mutation, right? Lighter punishment is what we call substitute to a lighter punishment. When it is 10 years, rigorous, it is changed to 10 years lighter punishment, normal sentence. Right. So commutation is nothing but when it is changing to a lighter punishment. Lighter punishment is what we have to remember in the commutation. Here it completely absolves, completely, or one keyword alone is enough, completely. Commutation is what we call it as lighter punishment. Pardon means completely. Commutation means mutation. Mutation is going to be a lighter punishment. So mutation is a lighter punishment. Then we have the remission. It's reducing the period without changing the character of the punishment. Reducing it without changing the character. Remission. The mission is again. So when you are going to some place, the mission is again re-established is what? Remission. So already you would have achieved something, right? So reduction, the period alone we have to remember. Reduction, the period is what we have the remission. Reduction, the period without changing the character of the punishment. Respite is lesser sentence than the original due to special facts like pregnancy. This is a lesser sentence because of special facts is what respite. Lesser sentence due to the special facts like pregnancy. Reprieve is a stay. So we have reprieve. What is reprieve? Reprieve is a stay. Right. Now what is pardon? Completely. Commutation is from to a lighter sentence. Commutation to a lighter sentence. Right. Then we have respite is because of lesser sentence, because of some disability like pregnancy, disability, because of two special factors. Remission is the reducing in the period alone without changing the nature of the punishment. Reprieve is nothing but a stay. So pardon, commission, remission, commutation, remission. Respite, reprieve. We have 5. Now there is a Supreme Court case. It is known as the Maru Ram versus Union of India, 1980. So Maru Ram versus Union of India, 1980. The Supreme Court held that the power under Article 72 is not an independent power of the President, but it is to be exercised on the advice of the central government. Right. In the Maru Ram case, the pardoning power is not an independent power. Pardoning power is under Article 72, right? So the pardoning power is not an independent power, but it is to be exercised on the advice of the central government. Now, Epuru Sudhakar versus Government of Andhra Pradesh, 2006. Granting the clemency by the President or the Governor can be challenged on the basis of following grounds. The order has been passed without application of mind. The order is malified. The order is solely irrelevant and extraneous. The relevant material has not been considered. The order passed suffers from arbitrariness. Even this can be challenged on what grounds is what we say Epuru Sudhakar versus State of Andhra Pradesh, the government of Andhra Pradesh in 2006. When it is without the application of mind, the order is passed without with it is nullified. The order is irrelevant. The order relevant material is not considered and it suffers from arbitrariness. Now we have a mercy petition. A convict under the sentence of the death is allowed to file the mercy petition within a period of 7 days after the date on which the superintendent of the jail informs him about the dismissal of the petition or a special leave appeal by the Supreme Court. He must file a mercy petition within 7 days. So there is a time limit for filing the mercy petition, right? A convict, we are having a death sentence. A convict who is having a death sentence, right? If there is a person and he is subjected to the death sentence, he is filing a mercy petition. Somebody with a death sentence, they are filing a mercy petition, right? Within a period of 7 days after the date in which the superintendent of the jail has to inform him. The 7 days from the date on which the superintendent is going to inform him that a special leave means, it is a special leave means, see my case again is what special leave to appeal by the Supreme Court has been rejected or dismissal of the appeal, right? The petitions are to be presented to the President of India. President seeks advice of the Cabinet. The appeal is examined by the Home Ministry and the Ministry before giving recommendations to the President takes the view of the state concerned. Then it goes to the Home Ministry, right? It goes to the Home Ministry and the Ministry also concerns the state. The Home Ministry here, it also concerns the state. There is no written procedure to deal the mercy petition. The President's pardon rejection delay is also subjected to judicial review. However, if the court finds that the process is taken by the President under Article 72 is not arbitrary or unreasonable, then it cannot be interfered with. Now, a curative petition is the last judicial corrective measure which can be pleaded in any judgment or decision passed by the Supreme Court, which is normally decided by judges in the chamber. A last corrective measure is nothing but a curative petition. Supreme Court is the final, right? Even if after Supreme Court has given a verdict, we can put a curative petition. So even after the Supreme Court has given a verdict, we can file a curative petition. What is the difference between the pardoning power of the President? The President can give the pardon sentence inflicted by the court martial as well, while the Governor cannot, and President can pardon the death sentence while the Governor cannot pardon it, cannot forgive a death sentence, but he can commutate, respite, remit, right? President exercises his judicial power for the punishment which is given by union law, whereas Governor is for the punishment by the state law. So President is for the union law and Governor is for the state law. 44th Amendment stated that the decision of the President is bound by the advice of the Council of Ministers headed by the Prime Minister. 44th Amendment is President may return the matter once for the consideration, but reconsidered advice should be binding. No constitutional discretion, only there is a situational discretion for the President. Right. What does it mean by situational discretion? Situational discretion in the sense the appointment of the Prime Minister. He does not seek the advice of anybody, right? When there is no majority in the Lok Sabha. Not the Council of Ministers. The Council of Ministers are appointed by the President on the advice of the Prime Minister. Right, only during the appointment of the Prime Minister when there is no majority in the Lok Sabha or when the Prime Minister dies in the office, dismiss the Council of Ministers if no confidence motion is approved. He has to dismiss the Council of Ministers and dissolve the Lok Sabha if Council of Ministers has lost the majority. Dr. Rajendra Prasad is the twice and unopposed Sanjeevan Reddy. Dr. Zahir Hussain has died in office in 1969 and V.V. Giri is the acting president. Right. So because Zahir Hussain was died in the office, V.V. Giri was the acting president. These are related to the president.